Hello, my lovelies, and welcome to Spring Tea with Curtin Washla. Today, we are going to talk about a serious and somber subject, but a very important one, and that is your end of life wishes. You hear me many times when I talk about estate planning saying, everyone should do this. These are no-brainers. These documents save you so much money and time and privacy. When it comes to your end of life instructions, however, it is very much your own personal philosophy as to whether you want to leave your wishes, whether you want your family to know, and whether you want those wishes and choices to have legal effect. If you do know what you want, I do say always get it into your documents. And here are the 3 ways we get that into your documents here in Illinois. The first is your healthcare power of attorney. The healthcare power of attorney since 2015 will give you 2 choices. You decide whether, if the doctors have determined that this procedure in place, this life support is just death delaying. Do you want it to be kept in there, or do you want to be let go? Do you want to be given just comfort care and be allowed to die naturally? Or do you want to stay in life support regardless of the possibility of recovery, regardless of the cost, regardless of any of those other factors? In the healthcare power, you choose which of those 2 you want your agents to follow, or whether you don't choose any, and then let them make the decision themselves if that time comes. That's the power of attorney for healthcare. Now that is you leaving that decision in their hands. Many people do not want to leave that choice in their family hands. Many clients have told me, I had to make the decision for my father, for my spouse, for my child. I don't want anybody to have to make that painful decision for me when my time comes. So you can take that end of life decision out of your family's hands and get it into a separate document called a living will declaration. The living will declaration recognizes that you have a right to refuse treatment here in Illinois, and many of our other states also have this type of declaration. You have the right to refuse treatment. You will be unable to tell your family and healthcare providers that when the time comes that you are at end of life and just being kept alive by life support. So you say in this document, when that time comes, and when the only thing keeping me alive is the life support, I want it withdrawn, I want comfort care, and I want to die naturally, and your wishes will be fulfilled. Many people ask me, is a DNR the same as a living will? How does that fit into the picture? And I say, a DNR is kind of the opposite of a living will. A DNR, do not resuscitate, is if you are naturally slipping away, that process brings you back to life, resuscitation. Whereas a living will, you are only being kept alive by life support, and you're saying to withdraw that and let you slip away. We typically ask our estate plan clients what they want, and if we know they don't want to be kept alive, if it's just death delaying, we get in place the healthcare power and we get in place the living will. A do not resuscitate, in my personal and legal philosophy, is really for a very different stage of life. Not when you're planning right now, when you're healthy, because if you did have a car accident or an emergency, it's my belief, and probably yours, that you should be resuscitated. However, if you're on hospice, if you're on an end of life situation, if you are in your 90s and your cardiac arrest, if you're resuscitated is followed by another cardiac arrest or respiratory arrest a day or 2 later, those are the times that having a DNR in place does make sense. A DNR has to be agreed upon by your doctor, has to be signed by your doctor, and often is just gotten in place when you are already in an end of life situation. So DNR, living will, healthcare power of attorney, all ways that you can explore your feelings about end of life. It's certainly not planning for everyone. I've always thought about it a little bit differently since a little lady said to me one time, but what about a miracle? How long shall I leave myself for a miracle? So you can leave end of life instructions, but maybe leave 30 days or 2 weeks on that life support for visitation by a miracle. So end of life instructions, many of you have thought about it. If you have not, have the conversation, have the thoughts, discuss it amongst your loved ones. If you know what you want, get it into your legal documents. This way, your personal philosophy will be fulfilled and you will have given it legal effect in your documents. So thank you for listening. I'm going to leave you today with a quote by Rebecca Wells. Life is short but wide, so live it wonderfully, lovingly. And I'm going to also quote Barbara Sher, who said, I'm not even sure that it's short. We have a wonderful life in front of us. None of us knows the day or the hour. So make your plans by all means for the end of it. And while we're here, standing in our shoes, living and breathe it, make the most of it. Much, much love. Thank you for watching. I will see you next time on Spring Tea with Carolyn Mothjaw. Goodbye.